I've written thousands of responses to the U.S. Patent and Trademark Office. When they review an application and require more information, or there's a procedural issue or a substantive refusal, they generally issue what's called an office action. Not only have I written thousands of office action responses for my clients, when I worked at the U.S. Patent and Trademark Office, I reviewed God knows how many office action responses from the applicants at the time. So I've taken all of that experience and I want to distill it into 5 things, 5 keys for writing an effective office action response. Number 1, read the office action thoroughly. I say this because the office actions are hard to read. They're poorly formatted. They're full of lots of jargon and statutes and cases, and they're oftentimes full of what's called form paragraphs, which is like essentially automated language about the topic. And to find the real meat, the real substance of what the examiner wants or what they're asking for can be challenging, and that's why it's very important to read it thoroughly. Number 2, once you've identified what the issues are that need to be responded to, you need to research carefully the facts and the law that apply to that issue. Generally, likelihood of confusion or merely descriptive are the 2 key substantive issues. When you're researching the facts and law on those issues, you can also use the trademark database tests to search for perhaps similar situations that, or similar trademarks that have gone through the process and that were approved or that were denied, and that could help your argument, or maybe have arguments within their case history that could help your arguments. Third key is clear writing. I've personally found that the most successful office action responses are not written like legal briefs, and they're not written like college essays, and they're not written like a business memorandum. They're really a combination of these things, mostly a combination of like a business memo and a legal brief. So you want to be clear and to the point and concise. You don't want to use a lot of flourishing language. It's not necessary. But you do want to outline what the law is, what the case law is that governs, and then discuss how it applies to the facts and issues at hand. The 4th key, this one might be the most important one, is effective evidence. Evidence is really what gets over the threshold in many, many cases in getting a refusal withdrawn. That's from my experience. Evidence can be from the internet, it can be from reference materials, it can be from other trademark registrations, third-party marks that are in use or registered. There's a whole variety of evidence, and there's a whole set of rules for how you introduce evidence. And there's a procedure for how you make the evidence effective. So you want to make sure that you have good evidence to support your arguments. Finally, the 5th key is to choose the most important key arguments in your response and not, as I've seen some do, throw the kitchen sink at it. So if in response to a likelihood of confusion refusal, there might be 5 different approaches one could take, 5 different arguments one could make, I generally would not make all 5 of those arguments. I would focus on maybe 2 or maybe 3 of the top most effective arguments that are hopefully going to convince the examiner. I find that if you throw all the arguments out there, it actually dilutes the strength of your arguments, and it actually makes you look like you're desperate and like you'll say anything to try to get it approved. So those are my 5 keys to writing an effective office action response. Of course, I also recommend that if you've received an office action, you talk to an experienced attorney who's familiar with these issues, because there is a lot of nuance to it. There is a lot of procedure. There are clearly a lot of specialty that goes into this. If you'd like to set up a call with me, click on the Contact Me button below, or find the Connect with Me button on my website.